and welcome to Episode 8 of the Principium Pod. I'm Sean Wilke, Director of Digital Services at Principium. Today we'll be talking to DataGlobe Group founder and CEO Michael Sim about the business impact of the General Data Protection Regulation, or the GDPR, and how businesses can prepare accordingly. But first, we'll round up the latest developments on GDPR's impact on Whois and the domain industry at large. ICANN is trying its best to maintain open Whois, but unfortunately the reality of GDPR makes the current model unsustainable post-May 25th. This does not bode well for the intellectual property community, as well as for security, threat intelligence, and anti-abuse professionals who rely on Whois to protect IP interests and investigate cyber attacks. ICANN unfortunately took up GDPR far too late in the process, making Whois fragmentation among the registrars and registries all but inevitable, at least in the short term until a permanent solution is established. And here's why. Last month we discussed ICANN's proposed Whois model and noted some compliance concerns such as data retention, the transfer of personally identifiable information in the underlying Whois data, and the purposes for collecting specific data points. These concerns were expanded by the contracted party house, consisting of the domain registrars and registries, arguing that it will take several months to develop policies and deploy systems to implement these policies. Notably, contractual amendments and waivers among parties in the domain name supply chain will need to be established, such as the registrar accreditation and registry agreements. Who will have access to underlying data if tiered Whois is approved? Who will oversee this process, and what does this process look like? Regarding data collection, ICANN included no legal basis for admin, tech, and billing contact collection. And lastly, the domain transfer process between registrars is a big question mark without full Whois access. So earlier in April, ICANN reached out to the Article 29 Working Party, a group of data protection authorities from each EU member state, for feedback on their interim Whois model and an enforcement moratorium until a permanent solution is established. The Working Party did respond, and while they appreciated the direction of ICANN's model, they still had serious concerns, namely the lack of detailed purpose for the data that ICANN wants to collect from registrants. Regarding tiered Whois access accreditation, they questioned the legitimacy of any third-party request beyond law enforcement agency access. The 2-year data retention period established by ICANN is arbitrary, they claim, so ICANN needs to provide relevant justification. Cross-border data transmission isn't addressed by ICANN. Bulk Whois access is non-compliant with GDPR. Rather, individual requests must be made. And finally, and most importantly, the enforcement moratorium that ICANN requested was not addressed. ICANN is meeting with the Article 29 party this week in hopes of addressing this moratorium, though we are unaware of any other GDPR moratorium from other industries at this time. The situation remains fluid, and we will be closely monitoring these developments. But at this time, it's looking like registries and registrars need to develop their own GDPR-compliant solutions for Whois. In other GDPR domain news, GoDaddy has caught the attention of the U.S. government. In January, GoDaddy announced that they would mask certain Whois data, such as registrant name and email address, and throttle port 43 traffic, claiming to combat spam generated by bulk Whois scraping on platforms such as domain tools, and to prepare for GDPR. This has upset other registrars trying to connect with GoDaddy during the transfer process, and has also upset intellectual property and security communities for masking this data. People in the IP community are complaining to ICANN that they have not enforced an otherwise clear violation of the registrar accreditation agreement, and are concerned that other contracted parties will follow suit. But these aren't normal times. In a month, all contracted parties will need to mask Whois data as a result of GDPR. In an interesting development, the National Telecommunications and Information Administration, or the NTIA, sent a letter to ICANN requesting that they investigate GoDaddy. More to come on this matter shortly. VeriSign, the registry operator for .com and .net, is one of the last remaining registries not to publish thick Whois data, though there is a plan in place to migrate all new registrations to thick Whois data by October 28th, while current registrations are to be migrated by July 31st, 2019. VeriSign is requesting a 1-year delay on its implementation due to GDPR uncertainty. It's almost certain that they will never migrate to ThickWhois at this point. And finally, a number of country code TLDs have announced and or implemented their Whois data minimization plans, such as .b for Belgium, .eu for European Union, .fi, .de, and .sk. But two registries, Nominate for .uk and COCA, manage several smaller CCTLD registries like .af for Afghanistan, .ht for Haiti, .hn for Honduras, however, announced that they will charge users to access Whois data. With .uk, law enforcement agencies will be provided free access, while third parties, including intellectual property owners and their agents, will be charged for the data, even though the registrant name and address will be redacted. Otherwise, full Whois data can be manually requested and obtained within 1 business day at no charge. COCA, on the other hand, is more explicit about Whois access for non-law enforcement agency access, stating that the IP community will be charged a $3 fee per request. Interesting times indeed. While we've been focused on GDPR's impact on the DNS, the regulation is much broader in scope and affects the everyday operations of organizations of all sizes. Here to help us navigate through GDPR is Michael Sim. Michael is the founder and CEO of DataGlobe Group, Inc., a privately held company launched in 2011, principally involved in cloud technology, consulting, and software development for the finance and energy industries. And of course, he is helping companies prepare for GDPR. Michael, welcome.
Thank you. How are you?
Good, thank you. So how did GDPR come about in an era when privacy has generally been an afterthought in people's lives?
GDPR came about to unify a disparate set of privacy directives, primarily ePrivacy, ePrivacy 2, PECR 2, and EPR, to provide a legally enforceable set of regulations. It was originally ratified in early 2016 and actually becomes enforceable as of 25th of May 2018. Its key objective was to ensure organizations had a framework which to deal with the privacy of individuals. The regulation mandates that companies take a risk-based approach to the collection and processing of data, and it focuses primarily on protecting the individual's rights.
So how do you think the law will be applied? The Cambridge Analytica scandal has really brought a spotlight on how large tech companies such as Facebook, Google, Amazon, and Twitter process and retain personally identifiable information. I can imagine that these companies will come under heavy scrutiny rather immediately.
Yeah, I agree. As a result of the recent scandal, Facebook has already introduced a new privacy management section for users in the EU so they can see what data is being collected and what is being shared, enabling those users to limit the availability of that data to third parties. Google, Amazon, Twitter will start to come under the same scrutiny some point in the next while, and it's only a matter of time before similar issues come up for other organizations. Realistically, you only need to look back at the number of data breaches in the last 12 months to see what's going on with this issue. Net result is organizations will have to think more about privacy and to justify the purpose and use of the data collected. There's an emphasis on organizations to demonstrate that they meet the compliance within the regulation and improve the capabilities to manage privacy and data effectively.
So what new personally identifiable information is included in GDPR beyond the scope of the legacy European Data Directive?
The new features of the regulation pertain to consent and profiling. According to the regulation, consent means any freely given, specific, informed, and unambiguous indication of his or her wishes by which the subject, either by a statement or by clear affirmative action, signifies agreement to the personal data relating to them being processed. The purpose for the consent is gained does need to be collected or specified explicit and legitimate processes. In other words, it needs to be obvious to the person what their data is going to be used for and at what point of the data collection it is used. Consent has to be demonstrable. In other words, an organization has to clearly show how consent was gained and when. and consent must be given freely. A key point is the ability to withdraw the consent, and it should always be able to do that as well. The regulation defines profiling as any automated processing of personal data determines certain criteria about a person, in particular to analyse or predict aspects concerning the person's natural performance at work, economic situation, their health, personal preferences, interests, reliability, behaviour, location or movements. This will certainly impact a lot of marketing processes and services, although the extent of this impact is yet to be understood. And where does profiling finish and selection start? Full personalisation and other servicing techniques, for example, rely on a degree of selection normally built on profiles, which is based on behaviour or purchase. So it's going to be an interesting question that comes to mind, is explicit consent now required for this?
And is GDPR only applicable to EU entities?
No. It's not only applicable to the EU and UK entities. Any entity or organisation globally collecting or processing data from citizens from the EU or UK, or any European Economic Area, will need to comply with these rules and regulations.
How do you expect it to affect the daily operations of a company, and what can they do to prepare at this time?
Well, there will be significant changes for the internal processes of organisations that they'll need to comply with the regulations. At this stage, if a company is not in a position whereby they are reasonably prepared, they'll need to expedite wherever they can. The fines for non-compliance can be hefty, and I'm sure that the regulators will be looking for some cases to benchmark the resolve to enforce these regulations.
So how do you see the market now? Are businesses prepared for GDPR? It seems like unprepared organizations will develop reactive retention and privacy policies, resulting in wide-scale disruption to their operations.
From what I've seen, a large number of organisations are pushing back to get additional time to be prepared. With the intended focus of security and privacy by design, many organisations are scrambling to put together some sort of framework to ensure a level of compliance. But so far, many organisations I'm working with, both here and in the US, are struggling to get there.
Under GDPR, will businesses be more or less hesitant to report data breaches?
Personally, I believe the status quo will stand, whereby organisations will try to limit the potential damage by minimising the scale or scope of any such breach. The regulations state that in the event of a personal data breach, organisations must notify the appropriate supervisory authority without undue delay and, where feasible, not later than 72 hours after becoming aware of it. This will certainly make businesses hesitant to report it, even internally.
And while the challenges are apparent for organizations, do you see any benefits and opportunities of GDPR? Also, can it help balance the privacy versus security debate?
I believe it's a start. Once the regulation becomes enforceable, it'll be interesting to see how it will evolve and what influence it will have on regulations in other countries. The privacy and security of individuals' data has now become front-page news following, the apparent meddling in the US elections via the Facebook from foreign state-controlled entities. Data privacy and security will become embedded into the fabric of our data collection going forward.
So with the enforcement deadline only a month away, it'll be interesting to see how this all plays out. Michael, how can people find more information about DataGlobe?
They can go to our website, dataglobegroup.com, or just Google us, anything they want. So, yeah.
Great. Thanks so much for your time, Michael. It's really good to get input from an expert on this topic.
You're welcome.
That'll do it for this podcast. As always, we're closely monitoring GDPR along with other important issues affecting brand owners. We'll keep you updated with any new information as it becomes available. Thanks for joining us, and please visit principiumstrategies.com for more information about our IP protection services. Take care. The Principium Pod is brought to you by Principium Strategies. Principium has been at the forefront of intellectual property protection for more than a century. Covering more than 180 available jurisdictions worldwide, our international trademark watch pairs state-of-the-art proprietary customized software with our network of trademark analysts who then review the results to ensure that you receive only those which will be relevant to your protected brands. Not only does Principium focus on Trademark Watch, but we also have an entire division focused on domain management, maintenance, and digital brand protection. Using Principium for your domain and online brand management can save your organization expense while providing unmatched service and security. We apply our legal, business, and technological expertise to relentlessly protect your brand. To learn more, visit principiumstrategies.com. Principium Strategies, the evolution of brand security.